Good afternoon, everyone. My name is Shelley Richardson. I'm the Executive Director of the Statewide Independent Living Council here in Illinois, and we are so glad to have you all today for this exciting webinar. It's called ADA Employment uh, Protections from Application to Promotion. And this was geared toward those of us that are seeking employment so that you know what should or should not be done when you're disclosing a disability or asking for a reasonable accommodation and stuff like this. And our presenter today is Oscar Gonzalez, and he is with the ADA Great Lakes Center, and we're very glad to have him. I want to give you a few housekeeping things up front. First of all, please remember that at the end of this webinar, we have a poll that only asks a couple of short questions, and we ask that you take the time to answer those. Those are very important for our evaluations to know what we can do better and if we're doing things okay. Also, in the chat, uh, you will see, first of all, as a reminder, if you haven't read it yet, we are recording this webinar. And yes, we will send out the recording. And yes, we will send out some materials to everyone that has registered. So in the chat, if there's some kind of technical difficulty or you have a question, you can ask it there. But on over, you will see a question mark with a Q&A underneath it. So if you have questions during the presentation, please add them right now before you forget them. And then at the end, for those that prefer to voice your question out loud, you will hit the raise hand button, and Tara will unmute you, and you can ask your question at that time. I want to give you a visible description or physical description of myself. I'm on the other side of middle age, and I have red hair and purple rimmed glasses. I'm a white woman, heavy set, and I am in my home office today. So my pronouns are she and her. So right now, I'm going to turn it over to Oscar, and he can tell you a little about himself and then launch into his presentation that I can't wait to hear. Take it away, Oscar.
Thank you, Shelley. So my name is Oscar Gonzalez. I am with the Great Lakes ADA Center. And so today, there's a little bit about me. I am a brown man with a beard, brown hair, do not wear glasses, and currently wearing a golf blue t-shirt. It's very hot today. And so I am currently sitting in a library booth so I can provide this presentation to you all. So it looks a little bit enclosed. And so I have been with the Great Lakes ADA Center for a little over 3 years. And what we do is provide technical assistance, which is a fancy way of saying that we are here to answer your questions on the ADA. Now, a little bit about what the center does is it is a federally funded to provide information and resources on the Americans with Disability Act to anyone that calls. So that means that if you have a question on the ADA, if your friends have questions, your family members, your employers, if a business has questions, architects, everyone can give us a call and we'll be able to, lead them to the proper resource. We surprisingly do get a lot of questions, especially, for buildings. So that is a very common topic, along with service animals and employment, of course. We are part of the ADA National Network. So the ADA National Network is made up of 10 regional centers. And so we are one of the 10. So what that means is that anyone that calls from Wisconsin, Minnesota, Illinois, Indiana, Michigan, Ohio, if they call the 1-800 number that we all share, all the centers, they will get connected to us. In the off chance that you move from California or Texas to Illinois, and you never change your phone number, you dial that 1-800 number, you might get connected with another ADA center, but we always do ask which state you live in so we can connect you to the proper resource. This is a system that was built in the 90s when it was just pure telephones, and if you did move, you did change your phone. But nowadays, people keep their cell phone numbers wherever they go. And so today we're going to be talking a little bit about what the ADA is, where it applies, and then focus really on the employment area of what protections for individuals with disabilities. So today I will share my screen, and of course, as I mentioned, because we are a technical assistance center, you are free to give us a call if you have questions late, a week from now, a month from now, maybe tomorrow. And so there's at least three of us in the center, so we are a small team. So if you call us and we're not able to answer your phone call right away, please do leave a message and we'll get back to you as soon as we can. We usually try to provide a response, either same day or at least the next day as best as possible. Now, if you would rather send an email or send a text message, those are also options that are available for our center, and we'll provide that contact information at the end of the presentation. And now let's go ahead and get started. Let me share my presentation here, my screen. All right, and if at any point in time, if you feel that I am speaking too quickly, please let me know, particularly because when I do these presentations in Spanish, we usually get done in about half the time. But that is more in the language part and the cultural. And so, as I mentioned, today we're going to be talking about ADA employment protections. And so, if you learn anything today, what I want you to learn is that the ADA applies to all areas of employment from the moment you start your job application until, unfortunately, sometimes the moment you're fired. So, all these all these steps, all these benefits, you do have protections to ensure that they are accessible to individuals that have disabilities. And so we have my email here. It's oganza2@uic.edu. If you do have any questions that you would like to address directly, it's OGONZA number 2@uic.edu. And so a quick disclaimer is, we are federally funded to provide information on the ADA, just purely information and resources. So we do not provide legal assistance. We do not provide advocacy, and we also do not take complaints or grievances. So if you do have a complaint or a grievance because of the ADA or are seeking legal assistance, while we may not be able to provide it to you, we can certainly guide you into the proper direction as to which organization to contact. So our mission is to enable all people with disabilities to live a life of equality and freedom, much like the ADA's mission of why it was signed into law. And so today we're going to go over a brief overview of the ADA. We're going to discuss as to what it means to have a disability under the ADA. We're going to go over employment, special terms, because some of these terms may be, you may not have heard of them before, but we'll describe what they mean. We'll also discuss what happens if you do have a discrimination complaint in the workplace. And then we'll have time for questions and answers at the end. So what is the ADA? So the ADA is a civil rights law that protects individuals with disabilities to ensure that they are not discriminated against and that they have equal access to goods and services, programs, activities, such as everyone else that does not have a disability. So this law was signed into or took effect in the 90s. And so it is a fairly recent law when compared to other disability rights laws. And so because it is a fairly newer law, sometimes the ADA doesn't fully cover certain areas. For example, we do get a lot of calls when it comes to housing, but because housing already has their Fair Housing Act, that for protections for individuals with disabilities, the ADA has kind of limited coverage because the law was already existed for that. And so, to be protected under the ADA, if you have a disability here in the United States, it doesn't matter what country you're born in, your age, your gender, religion, skin color, race. If you have a disability, you have protections. So, individuals that are in Illinois will have the same protections as the people in California, will have the same protections as those in Florida. This is a federal law, so that means that every single state has to follow this law. So this is the bare minimum for everyone. And so the ADA kind of focuses on four key areas. And so one of the key areas is employment. And that's the issue, the item that we will discuss today. The second item or title, as they're called, is state and local government services. So this means that any kind of program or service that the state provides or your local city provides, such as the DMV, your parks and recreationals, um, your libraries, those are all covered under Title II. So any kind of state or local government that is providing services, programming, and facilities. Facilities also are very important to be accessible, but we always can get into very complicated questions very fast, mainly due to the age of buildings. But we'll move on to the next title. Title III is typically called public accommodations for the fancy legal term. But that what essentially means is any business open to the public. So if you're going to your grocery store, your laundromat, your movie theater, all those businesses should be accessible to individuals with disabilities for their goods and services. This also applies to nonprofits. So, if it's a business that's open to the public, that anyone can enter and utilize their goods and services, they have to be accessible. They have obligations under the ADA to be accessible. Then we have telecommunications, so that individuals with speech and hearing disabilities are able to utilize services, telephones, captioning. So those are also kind of things that fall under. And then we have kind of miscellaneous clauses under Title V, which also speaks about retaliation being prohibited. So if you do decide to, exercise your rights and ask for a reasonable accommodation or a reasonable modification, and you obtained it, but then someone else starts acting negatively because you did exercise your right, retaliation is also not allowed under the ADA. All right, let me move into the next slide. Okay, so the next slide is disability and the ADA. So because disability and the ADA is so broad, it was meant to include as many people as possible. So for example, while Social Security or Veterans Affairs might have their own list of what counts as a disability and what percentage you have of a disability to qualify to be eligible to receive their services, the ADA doesn't have that. So the ADA is, as I mentioned, is a civil rights law. So it means that their definition is to include as many people as possible. So under the ADA, there's three methods or prongs, as they call it, to be qualified or eligible to, not be discriminated from entities. So the first one is if a person has a physical or mental impairment that substantially impacts their daily life activities. We'll go over what that means in a second. The second one is has a history or a record of such an impairment. One of the common examples that we have are people that were diagnosed with cancer, and then went into remission, went into treatment, and no longer have cancer. And so, them having a history of that cancer does not disqualify them from possibly being denied a job for health insurance purposes, or because they have a cancer and the employer thinks they might take more time off if the cancer returns. That's where the history of such an impairment comes in. And then the third prong we have is perceived by others. So if an individual, if someone thinks that you have a disability, but you don't have a disability and they deny you because of that, services or goods, that is the third prong. So for example, someone that has scars and is applying for a secretary position or a front office position, but the employer perceives that as them having a disability, because it may affect customer service, that is where that prong may play into it. But of course, everything is always on an individualized basis for individuals with disabilities. So, what three people may have the same disability, but not everyone's going to be asking for the same accommodations or modifications. And so, because it is a civil rights law, it means that individuals, if they have the disability that falls under one of these three categories, they don't have to apply for anything. You're automatically protected. You have the ability to ask for reasonable accommodations and reasonable modifications. And looks like we're doing a swap. All right, and so there, you automatically have protections. And so what we're trying to let you know here today is that because you already have these protections, you are eligible to ask for reasonable accommodations in the workplace. And so, what exactly was a major life activity? So, a major life activity or bodily functions includes things that you may have difficulty because of your disability. So, we have eating, sleeping, walking, moving around, breathing. We also have cognitive functions. So, because the ADA also covers physical or mental conditions, it means that if you have issues thinking, memory collecting, those are also major life activities. We also have sensory functions. So we have, individuals that have hearing and sight disabilities, and then tests. If someone has dyslexia and difficulty reading or learning, that is also a disability, and you can ask for reasonable accommodations in the workplace. And then bodily functions as well. If individuals have difficulty because of their kidneys or lungs, that affects their daily life activities, individuals can also ask for reasonable accommodations and modifications. So these are just examples. This list is never usually exclusive, or yeah, no, this list is never that close. So it's always open as long as it really affects an individual's daily life activities. And so some examples are of disabilities. We have what is considered to be perceivable. So those that are visible, individuals that have hearing conditions, visual conditions, those with mobility disabilities, such as those wearing wheelchair or utilizing wheelchairs, individuals with limb differences. And then we have invisible disabilities, or in this case, they might say non-perceivable in the workplace. So this is important because in order to have protections under the ADA, you have to let your employer know that you have a disability. Because especially if it's non-perceivable. So sometimes this can be, if you have anxiety that affects your daily life activity, or depression that affects you, and sometimes even episodic disabilities that you might occasionally have flare-ups, or let's say epilepsy, things of that sort where they're not constant, but are more episodic or cause of flare-ups. Those can also be asked for accommodations, and because they are invisible, sometimes your employer might not easily see why you may be having barriers in the workplace. And so some of the important concepts that we need to learn about today, especially when it comes to the ADA and employment, are a qualified individual with a disability, reasonable accommodations, which I've already said multiple times already. We are also going to be discussing about, when should I talk about disclosure, or when should I talk about my disability with my employer. And then will also be talking about medical documentation, because sometimes the workplace may ask for, some kind of documentation that provides information about your disability and, what kind of barriers you're facing for your job. And so, as I mentioned, Title I covers employment. As I mentioned earlier, I'm in a closed little booth, so it is starting to get a little hot in here under these lights. And so the ADA applies to employers who have 15 or more employees. So as I mentioned, because this is a federal law, this is the standard across all the states. So that means every single state that has employers that have 15 or more employees have obligations under the ADA. Now, sometimes states may also have their similar laws to the ADA that provide broader protections to employees. So, for example, here in the state of Illinois, their local state law for human rights and disability protections name that employers have to have one or more employee. So that means that if an individual with a disability is working for an employer that only has 10 employees, that employer may not have obligations under the ADA to provide reasonable accommodations. And so if there is a kind of discrimination complaint, then the ADA may not apply to the situation because they have 10 employees. But because the state of Illinois says it's only one or more employee, that means that if you do have discrimination on the basis of disability, you can file, but with the state of Illinois because that is their state law. So while you may not be able to file at the federal level, you can certainly file at the state level. And so um, as I mentioned earlier, the one thing I would like you all to remember is that the ADA applies to all phases of employment. So that means that if an application is inaccessible, you can ask for reasonable accommodations. If you're having an interview, you can also ask for accommodations there. It applies to hiring, promotions, trainings, pay, and any other benefit. This includes that company picnic. That company picnic, whichever location they choose, they should make sure that it's accessible. That party that they have at the end of the year, that location should also be accessible, or that event should be accessible. So, that's what they mean by all benefits provided to employees. And so the ADA also does cover all or all employment areas. So that includes facilities as well. That means the bathrooms, their break rooms, the lounges, those have to be accessible to workers. So it's not just for your job functions, but also the areas that are common. There are some exceptions to employee work areas only, but that's a little bit more detail. And of course, if you do have questions, you're more than welcome to give us a call if it is a work employment area. And so another thing to note about the ADA is that it is confidential. Any information that is provided to your employer should be confidential. They should not be sharing those details with anyone that is not to need no not to that is not on a not to need know basis. And so what that means is that if you do ask for a reasonable accommodation, you should ask either the HR department or your supervisor, and then they will work together with you to kind of look at what kind of reasonable accommodation should be provided. Now, some exceptions, of course, are, if for some reason you work in an environment that requires safety issues, such as, let's say you may have an allergic reaction, and other team members might need to know what to do. Um, Only those that need to know may have that knowledge of that disability. So if there's an emergency action plan, so in case someone is fainting or has an episode during their job, those individuals that are trained and told about the situation, ideally your supervisor or HR will the ones be the handling that. It also means that, their job maybe have to share with federal agencies if that's also part of their duties, but there are always like kind of general exceptions, but for the most part typically only HR, typically only your supervisors need to know, so they cannot be sharing that your disability to other employees. So for example, if you have a longer lunch break to take your medication, or being able to have extra periods for you to walk around, your employer does not need to provide the reason to their other employees or your coworkers. That is confidential. And so whenever you do provide information that is medical, that information should be kept private, and they should keep those documents in a separate file. Those details should not be in your personnel file, but another file that is separate with only your medical information. Here we go. So this is where we have to let individuals know what a qualified individual means. So a qualified individual under the ADA is someone that will meet, the skills, the experiences, education, or requirements that the job requires to do the essential functions with or without a reasonable accommodation. So here, I do have an example in the next slides, but essentially, when you look at a job application, they're going to have a list of requirements, minimum requirements. And so those are, the kind of criteria or tasks that individuals need to meet to be able to apply for the job. And so a qualified individual will be those that meet the minimum requirements. The job or an employer may or place preferred um, qualifications, but the minimum qualifications are what is for the qualified individual. So that means that having a disability does not automatically mean you obtain the job, but you also have to be able to have the requirements such as the certifications or the education requirements that job also requires. And so, with or without a reasonable accommodation. And so that is what essential means. And then we're going to go over reasonable accommodation in a second. So a reasonable accommodation, you're going to hear this a lot, especially if you're talking about employment in the ADA. So a reasonable accommodation is a change in the workplace environment or structure or equipment that allows a qualified individual to continue doing their job and to keep getting the same benefits as everyone else. Now, accommodations here are considered reasonable if they do not cause an undue hardship or a direct threat. Now, reasonable, of course, will vary depending on the job and depending on the company. And also, it might depend on a year by year basis, depending on finances. So, an undue hardship means that it is difficult to obtain either administratively or financially. So sometimes individuals may ask for certain accommodations that are technology based, and the company might not be able to procure them because it may be too expensive for them to obtain it. So that might be a example of an undue hardship, but there are always a little bit of alternatives, and we'll discuss that in a few. Now, a direct threat means there may be safety issues, both either to the employee or to other employees. And so this, of course, as I mentioned earlier, will vary by employer, will vary by the job structure. For example, well, not recently, but as I mentioned earlier, we do take calls from individuals. We received a call from an individual that was a truck driver. And so they were talking about how their company was no longer allowing them to drive the truck because their disability was causing a direct threat. And so, how was this person causing a direct threat? Well, his condition was he has diabetes. And so, while we may not often think about diabetes as a disability, it affects your bodily functions. So it affects how your pancreas produces sugars. So your sugar levels will, cause different changes in your body, both physically and mentally. And so essentially, if untreated, you might also affect your eyesight. And so this truck driver was starting to lose his eyesight. And so he was no longer able to renew his license when he had to go do that. And so his job, because he was no longer able to renew his license, had to essentially let him go. Because he no longer had the ability to do the essential functions of his job, and there was no other position that he could be moved around to. And so that is kind of a direct threat because he would be a hazard to individuals on the road if he's not able to drive his truck, especially something that is big enough to require a commercial driver's license. So that's kind of an example of what is a reasonable accommodation and why a direct threat or and essential functions and qualified individuals all kind of come in together. And so here we have another example of a qualified individual. We have that an individual who has paraplegia, which is lower body paralysis, applied for a secretarial position and is required to take a typing test as part of the application process. So the testing facility has two steps at the entrance, and noting that the employer decides that they can take the test at a different location as an accommodation. So as I mentioned earlier, accommodations, reasonable accommodations, can be asked at any point during the employment process, which of course includes the application itself and during interviews. Now, this individual, of course, is able to take the typing exam, but in this situation, the individual failed their typing exam, which was the minimum required for his essential functions. And so the employer does not have to do any further reasonable accommodations for the individual because they are no longer qualified to continue with the application process because they did not meet the minimum of the typing exam. And so, you can still get accommodations while you're interviewing, but, if for some reason, as long as it's based on merit, you are no longer eligible to move forward to the next process, that is where the accommodations kind of end. But if you do meet those typing exams or requirements, then, as you move forward, the job still has obligations to provide you with reasonable accommodations. Now, so reasonable accommodations can be multiple things. So they can be work schedule modifications, which means that you can possibly start early, leave late, take a few different breaks, changes to the work environment. So being able to work remotely, be able to work 2 days, 3 days out of the week, equipment and technology. So individuals may utilize screen readers. Your job may be providing you with standing desks or larger screens, policy modifications. Those may be being able to eat outside of your break areas to maintain your blood sugar for your diabetes, communication accommodations. So if you have a hearing disability and you are going to a meeting with every team member, captioning or ASL may be a method that your job provides to you so they can communicate with you. Job restructuring, so that means, passing along some of the marginal functions to someone else, and then reassignment. Reassignment is usually the last possible step as a reasonable accommodation. If your employer, if you no longer meet your essential functions of the job, such as that truck driver, your employer can also do a reassignment as a possible reasonable accommodation to a different position if it's open and available. It does not mean that they have to create a new position, but you also, if there is a position open and available, you also have to meet the eligibility criteria to be in that new position. So, and the important thing about reasonable accommodations too is that all these examples that I provided, they're going to be different for everybody. Reasonable accommodations are on a case-by-case basis. So they're always going to be individualized. You or your family members know best as to what would the preferred accommodations would be to remove that workplace barrier. So that is also important. And the reason why I say family is because individuals, you don't have to be the only one requesting reasonable accommodations. Other people can also help you with this process. And we'll go a little bit over that in a second. Okay, so as I was talking earlier about, well, let me go back one second. The job restructuring. So essential functions are the reason why you're there for your job. So these are the basic job duties that you need to perform and do with or without a reasonable accommodation. Now, the job has to determine, what is exactly considered an essential function.
Oscar, I need to interrupt you for just a minute. Can you speak up? Some people are having a hard time hearing you.
Yeah, of course. Let me put the mic a little bit closer to me.
Thank you.
Is this a little bit better?
Yes.
Oh, okay. I'm sorry about that. All right. So, as I was mentioning earlier, the essential functions are the job duties that you have to perform. And so one of the reasonable accommodations that can be done are restructuring your job. So sometimes you don't always have to do your marginal functions. Those can be passed along to someone else. So, an essential function by the EEOC's definition is, whether the position exists to perform that function, the number of other employees available to perform the function, and the performance of the function that can be distributed. And so the degree and expertise and skill of the individual to perform that function. And so an individual will not be considered unqualified simply because they cannot do the marginal or incidental job functions. So if it's not an essential function and your job is possibly trying to eliminate you because it's a marginal function and you are an individual that received reasonable accommodations, that may be considered discriminatory. And so how does this kind of look like in an example? Here we have it. We have a marginal function example where a janitor who had a leg amputated because of complications can perform all his essential functions without an accommodation, but he has difficulty climbing into the attic to occasionally change the air filter. So, because that is something that is not frequently done, there are multiple janitors on site. The employer can pass along that marginal function to other employees. So that is how this kind of looks like a marginal function. Can it be moved to other employees? Is someone else available to do that? This, of course, as I mentioned earlier, is on a case-by-case basis. It really comes down to how many employees are available and how many of those employees are eligible to do the essential functions of that job. And so while you're starting to apply for jobs, there's a few things that are not allowed. So before you start working at a job, generally the employer cannot ask any kind of questions about disability or the nature of your disability. So those are not allowed. Before you get a job, while you're still interviewing, they can also not ask for any kind of medical exams. And so this essentially means that they cannot, ask you, do you have a disability? And so if you do have a disability, but do need accommodations to, participate in that interview, you can certainly ask for reasonable accommodations. And they do have to provide that to you if you are an applicant. Now, when I mean generally, the employer cannot ask about your disability. If it's perceivable, they can kind of ask, how they would be able to do their job with or without a reasonable accommodation. So that's something where we get into is it perceivable, is it not perceivable? So they can ask those kind of questions, but they can't directly ask, do you have a disability? Sometimes because of certain other federal laws, or requirements, some employers may ask a voluntary question, and so that is up to the individual if they would like to disclose that kind of detail. Now, pre-employment, as I mentioned, they are not allowed to make you do any kind of medical exam if they do not offer you a position contingent of a medical exam. If you're not hired yet, they cannot ask you to do any kind of medical exam. The only time you have to take a medical exam is if they are requiring this of every single applicant that goes into that position. So that means that, every applicant with or without a disability needs to take the exam. So that is the only time medical exams are allowed prior to that conditional offer or prior to employment. Now, the other thing we will have to mention is that the drug tests are, the ADA does not prevent employers from asking applicants to do drug tests. Drug tests are not considered a medical exam under the ADA. So, illegal use of substances are not permissible. I will note, though, that if individuals are legally utilizing substances that are prescribed and using them as intended by their medical providers. If that shows up in a medical exam, you might have to disclose as to why, and then provide, discuss it with your doctor to be able to provide that kind of notification. But for the most part, medicinal use or illegal drug use can be a reason for firing. That can be also a very complex question to answer, as the ADA does protect individuals that have substance use disorder. because primarily that affects individuals' ability to function when it comes to, how long they've taken it and how it affects their daily life activities, because it could also be a cognitive and bodily function, or it can cause those kind of disabilities based around substance use. And so once you do get hired, what can they ask? So once they hire, they can no longer ask you about disabilities. And they can only ask for medical exams that are necessary to the conduct of employment. And so this also applies to voluntary medical examinations for employee health benefits. And we have that, as I mentioned earlier, when it comes to direct threat. So if it's a safety concern, they can kind of ask for a medical examination, but it has to be objective based evidence. It cannot be based on speculation. It cannot be based on gossip or theories that they may have. They have to have some kind of objective base awareness that, concrete proof that there's something is occurring, and there may be because of your disability. Then they can do kind of a medical exam for these kind of reasons, or exams required by other federal laws. And I do have an example of that in the next slide. So we have almost this is similar situation to the truck driver. We have an example of an employment medical examination. We have that a forklift driver or operator works at a warehouse lifting product pallets that weigh tons. During a break, the forklift driver becomes lightheaded and has some difficulty catching his breath. Now, he spoke with the supervisor. The forklift driver says that this has happened to him a few times during the past several months, but he did not know why. Now, at this point in time, they have not told their, employer or the supervisor about, needing a reasonable accommodation. Therefore, his employer does not even know he has a disability, but he sees that the employee is kind of almost fainting on the job while operating heavy machinery. So because that is an objective base, and there are seeing that there may be some risk that this individual is experiencing while doing his essential functions or his job, they can ask for medical clearance or medical documentation to make sure that he's okay. So because the employer has a reasonable belief based on objective evidence that the employee will pose a safety concern, and therefore they may ask for the forklift driver to have a medical exam to review whether the symptoms he is experiencing make him unfit to perform his job. So that's where as I mentioned earlier, it has to be objective based. They have to kind of have more concrete evidence as to why you may need a medical exam, because it has to be related to your work and work-related duties. Okay. Now, disclosure of a disability. This is when, the protections under the ADA kind of start. So if your employer does not know you have a disability, then they have no obligation to provide reasonable accommodations. The employer is required to only accommodate a known disability for a qualified employee or applicant. And so, letting your employer know they have a disability is important if you have a barrier to your work. So if you're having issues because of your disability, starting this conversation starts the protections under the ADA. It can be very informal. It can just be a simple verbal communication, but there really is no policy that dictates what needs to be done. So every employer may have their own different ways of, filling out that reasonable accommodation request. So some employers may be okay with just a verbal communication. Other employers may require you to fill out forms that places that in writing, but there is no set process for what kind of forms you need to fill out under the ADA. And so, as I mentioned earlier, reasonable accommodations are a case-by-case basis, and what is effective for you may not be effective for others. What is effective for others may not be effective for you. And so it's important to kind of come into this discussion with different accommodation requests, or kind of examples of what you would like to see to eliminate that barriers. Um, and so, because this is kind of a ongoing conversation, it's typically called the interactive process. But this is an informal conversation and a formal conversation at the same time to kind of see what is available for you. Now, if you do not have any barriers at your workplace and you have a disability and it's not affecting your productivity, then there's absolutely no need to disclose. But if you feel that you may get in trouble because of your disability, if your disability may affect your production or may be affecting your ability to work a certain task, then at that point you should possibly tell either your supervisor or your HR personnel that you would like to have, a reasonable accommodation. And so, as I mentioned just a few seconds ago, if the individual does not request an accommodation, then the employers are not obligated to provide one. So if they don't know that you have a disability, they don't need to provide you with a reasonable accommodation. And you may get penalties if, you are facing some kind of productivity or job related tasks decline because of your disability. So the ADA kind of starts covering you the moment you disclose. If, for example, you have penalties against you because of your disability and you know your production values are dropping, but you never let them know because you don't have a perceivable disability, those penalties will be on your record. But if you tell your employer that, hey, I have a disability, my productivity is starting to affect me, can we discuss reasonable accommodations? Now, in the future, let's say if you receive another penalty, they would have to kind of look at your reasonable accommodations first and see if that reasonable accommodation can still be effective. So now they kind of for any kind of penalty moving forward, it kind of starts that discussion like what's going on, are your reasonable accommodations working? It does not mean that your previous penalties are removed because, as I mentioned earlier, the employer does not have an obligation to provide reasonable accommodations. If they don't know you have a disability, those penalties are there. But moving forward, they do have an obligation to kind of have that discussion with you to see what they can do to help eliminate that barrier. Now, if you do ask for a reasonable accommodation and it is not a perceivable disability, the employer may ask for, a little bit more information about you. So they may ask you to provide medical documentation. So at this point in time, you may have to go to your doctor, you may have to go to your rehab therapist, your psychologist, anyone really that has, substantial knowledge of your disability and barrier that is an accredited professional. Um, I think I'm getting ahead of myself, but yes. But as I mentioned here for the last bullet point, disclosure of a disability, no disclosure of a disability is required unless you are requesting a reasonable accommodation. So if your job does not, or if your disability is not causing a kind of barrier or reduction in productivity, then you don't need to disclose unless, you are looking to seek a reasonable accommodation. Here we have an infographic. So discussing about reasonable accommodations and the interactive process, as it's called, to have these kind of conversations with your employer. So we have a watch that says can be done at any time. So it doesn't matter if you were working there for 1 day or a month, 5 years, 10 years, you can ask for a reasonable accommodation at any point in time whenever you see that there is a barrier to your job. It is confidential. So only HR, only your supervisor, only need to know people are required to know. Your other coworkers don't need to know why you are getting that extra time or extra help. It's protected under the law. So this is a federal law, so there is a federal agency that enforces this, and it is, for every state in the United States. It is the bare minimum that everyone has to follow. But of course, as I mentioned earlier, some states might have greater protections. And be prepared for medical documentation if you do make this request. And so, what does medical documentation look like? So here we have, if you're or if your need for an accommodation is not obvious, so if it's a non-perceivable disability, they may ask you to provide information from an appropriate professional. So, if you have more than one disability too, it does not mean that you have to provide them a list of all your disabilities, just the one that's affecting your job. So only the one that you need the accommodation for, only information for that. So your job cannot request you to provide a full medical history if during this reasonable accommodation process. So only the disability that is affecting the barrier that you have at your job. So but if you have, multiple disabilities and each disability is, affecting different parts of your job, you may have to provide, multiple documentations for each disability for each or job reasonable accommodation. Now, another common question that we get is, or calls that we get, are individuals wanting to know, hey, do I have to get this from my doctor? Can my therapist also write a note? So the EEOC is the agency that handles the ADA, and they have written guidance that states that, it's not just doctors. It can be nurses, physical therapists, occupational therapists, speech therapists, vocational rehab specialists, and licensed mental health professionals. So any of these individuals can provide you with medical documentation as long as it's sufficient information that provides, the need for the accommodation and your disability. And so, what should the documentation provide? We often also get calls from doctors asking what should they write in the note. Well, we cannot specifically say you need to do this, this, and this. We will note to them, what the EEOC says is sufficient. So, if you do have to go to your doctor to get a letter from them, it has to, one, describe the nature, the severity, and duration of your impairment, the activity or activities that your impairment limits, and to the extent of which your impairment limits the employee's ability to perform your activity or activities. And it also needs to kind of address why the need for the reasonable accommodation is needed. We have gotten a call from employers that ask, can your doctor give you different reasonable accommodations examples? The doctor's role is not to provide reasonable accommodation examples. That's a conversation more between you and the employer. The doctor's just there to kind of provide the information as to why your disability is affecting your job and, the need for a reasonable accommodation. Now, if you do want to provide kind of samples, the Job Accommodation Network is another resource to utilize. They do have sample letters that you can take to your employer, and that way, oh, not your employer, I'm sorry about that, to your doctor. And that way your doctor can kind of see examples of what they should provide to, what they should write down as they can take that back to your employer. Okay, and so effect, effective accommodations. Um, and so here we go into the next step of, a reasonable accommodation. So reasonable accommodation has to be reasonable. So absent undue hardship, absent direct threat, if an employer is not able to provide you with your preferred accommodation, they have to provide another alternative that is equally effective. And so when you do go to ask for a reasonable accommodation, um, find multiple accommodation examples that may be related to your disability. The Job Accommodation Network, again, they have A to Z dictionary. And so this A to Z dictionary provides different disability types and different accommodations based on disability types. And so if you are looking for different examples to possibly take to your employer based on your disability, we suggest you start looking there as well. That way you are prepared in case, your preferred accommodation is not available. There may be other alternatives that you and the employer can kind of talk through and see if it's effective. And so if your accommodation may be too costly, and the employer is able to find something that's, a little bit less costly for them, they can certainly provide that to you, as long as it's effective. So at the end of the day, they do get to choose which accommodation to provide, as long as it's effective. And effective, of course, will vary based on you, because you should be having a conversation with your employer, at different intervals or different periods of time, to ensure that your reasonable accommodations are still being effective a year from now, 2 years from now, because sometimes disabilities do change, and so the need for the accommodation that might have been working for you today may not be as effective for you 5 years from now. So, that conversation is still part of the interactive process, which is an ongoing conversation. So the reasonable accommodation doesn't stop the moment they provide it to you. It's an ongoing discussion between you and the employer. And so, if they can also provide you accommodations, to you, but if and you can also deny accepting that accommodation. But if you deny an effective accommodation, then at that point, the employer may have already completed their duties under the ADA and no longer have to be able to provide you another form of accommodation. So if they provide you with an effective accommodation and you say no, and you still have issues with your job, you may no longer be qualified to do the job. And so they may ask you to be removed. So that's something to also consider. But of course, they cannot force an accommodation on you. And so, well, here we go. The interactive process is ongoing. So as I mentioned, the interactive process doesn't stop the moment you get your accommodation. It is an ongoing conversation. And so it can be very informal. You can just have a simple conversation with your employer. There was one time I was having a discussion with a parent who worked at a fast food restaurant. And so what they were discussing was, because of their disability, they had to go to the bathroom pretty frequently. They themselves did not uh, to say they had a disability until after I mentioned different examples of disabilities. So they say, I have this. I asked my supervisor if I could use the bathroom more times, and they said, yeah, okay. And that was it. Sometimes a reasonable accommodation or the interactive process can be as quick as 5 minutes, uh, verbal conversation. But however, sometimes it might be a prolonged conversation that might take a few weeks or a few days to kind of sort out. Um, and so while it can be informal, it can be verbal, we do highly suggest, that any kind of requests be done in writing. Any kind of answer ideally should be kept in writing, because if there is some kind of mishap in the future, these kind of documents can be provided to the appropriate agencies if there is discrimination, if there's retaliation. Make sure that you have a proper log of who was responsible, what was the incident, when did it occur. The more information you can provide, the better it is for the investigating agency. And so, as I mentioned, other individuals, your family members, your vocational rehab coach, your caseworker can request an accommodation for you. So other individuals can, ask your job for a reasonable accommodation, and you don't have to do it yourself, so that you can be supported during this process. And so if you have children that have a disability as well, you can ask for a reasonable accommodation that is for them, if they have difficulty expressing that. If you have adult children as well, that's something that you can also help them out with. And so, as mentioned, this is in good faith. The employer should be having this conversation with you at periodic times, just to make sure that the effective accommodation is still being effective. And there is no timeline either for this process. It should just be done as quickly as possible. So if an employer is, you know, if you ask for a reasonable accommodation, what may be a considerable timeline may be different on each case, but generally as soon as possible. So if they receive an accommodation for you, they should start working with you within days, within, at least within the month. And then the same thing applies backwards. So if they ask you for any kind of documentation or supporting information, then you should also provide it as quickly as possible. So it is a collaboration and conversation that should be had between both. Okay, and so now discrimination and retaliation. So here is one of the phone calls that we do get pretty often is when individuals believe that they have faced discrimination in the workplace, either because their job is refusing to process any reasonable accommodation. An employer is making derogatory comments or negative comments. Other employees are also, doing negative comments and your employer is not taking any action. Or even, let's say, as I mentioned, you ask for a reasonable accommodation. You keep doing your job. You keep, nothing has changed, but now you're receiving negative marks on your job, even though it stayed the same. That may be retaliation. It may be them, saying, you exercise your rights, you made us do something that we didn't want to do, and now we're going to, make it worse for us as a business because now they can be investigated. And so it is unlawful to make employment decisions based on a protected status. So that means that disability is a protected status. Harassment is also a protected status. So you cannot harass individuals because of their disability. You cannot retaliate an individual for filing a charge too. So if you do make a complaint, they cannot also retaliate against you because of an investigation that has occurred to them. Or, denying any kind of employment opportunities because of a marriage or association to an individual that has a disability. So how does this apply? Let's say you have a family member that has a disability. You yourself do not have a disability, but your employer cannot deny you that promotion or deny you the ability to go on a work trip because they think that your priorities are your family, which for many of us that our family is a priority, but because they have a disability, they think that it's going to impact your workplace. So that's where the association kind of comes in, where they believe that your commitment to your family is going to be negative for their business. Because they have a disability, so you may take more time off to take care for your child that has a disability or your spouse that has a disability. So that is where the association of an individual with a disability kind of comes in. Now, as a person that does not have a disability, but as a family that does have a disability, you can ask for a reasonable accommodation. Reasonable accommodations are only for individuals that have disabilities. So a qualified employee with a disability. And so if there is discrimination, because this is a federal law, the U.S. Equal Employment Opportunity Commission, the EEOC, is the federal agency that is in charge of enforcing Title I of the ADA. So only Title I. As I mentioned earlier, there's a few titles for the ADA. Title II, state and local government, and businesses open to the public, Title III. Those are enforced by the Department of Justice. So if you, for some reason, have a complaint on those other entities, the Department of Justice is the agency that enforces those two titles. Telecommunications, that's the FCC. But for employment, it's the EEOC. And so they do have a time limit listed for them if, there is discrimination or retaliation. Ideally, they want you to do it as quickly as possible. And the time limit is within 180 days of the incident. But if the state also has a similar law to the EEOC, like Illinois does, then the time frame jumps up to 300 days from the date of incident. So it gives you more time because what they end up doing is a joint filing. So they'll investigate, they'll provide the information also to the state, and so it just both the federal and the state agency will work together to do that investigation. And so, as I mentioned, it's highly encouraged to keep everything in writing because if you are submitting a charge of discrimination, then they will want to see any kind of evidence that you may have. And there is no cost of filing. So you, with the EOC, you can file electronically. You can do this on their website. You can also call your local office and they may set up an appointment time to kind of go over the information and content and collect details. That way, you can, there's multiple ways of filing because they also have to have accessible services, but they're under a different law. They're under the Rehab Act, Section 504. But the both laws are very similar in what they being able to access services and not discriminate against individuals with disabilities. And so now we have a little bit of time for questions. But before the questions, I will provide our contact information as well as resources. So here we have the EEOC's webpage. It's eeoc.gov. We have the Department of Justice's webpage, which is justice.gov. We also have the ADA National webpage, which has plenty of resources and publications that provide information on the ADA, including the employment hub. So, that covers various topics around employment. We also have the Job Accommodation Network, the A to Z dictionary. So that is sjan.org /a-2-c.cfm. Oh, I'm sorry, I forgot to put the ADA National Network's webpage. So that's adata.org. And then here's our information. So as I mentioned, we are one of the 10 regional ADA centers. We do have a toll-free line. It's 1-800-949-4232. We have our webpage at adagreatlakes.org. We also have plenty of webinars available at adatraining.org. And so any information that you give or that you provide to us through your phone call, through your text message, through your email is free and confidential. We are here as a resource for you. Please do feel free to give us a call if you have additional questions. And then we do have a listserv and monthly newsletter that provides various topics around what's going on in our region. So, we provide information of news in all our states around the ADA. So we also do have various forms of social media if you do want to follow some of the content that we have there. And now, of course, I would like to thank you all for listening in to me go on about employment. We can certainly have this talk for a few hours because it can get very complex and there's way more things that are more in depth. But this is kind of a quick overview of what your rights are before employment, during your interview process, and then of course once you start working there.
Okay. Well, thank you so much for your presentation, Oscar. I really appreciate it. We do have some questions, and I'm going to let Tara read them. Also, I want to remind everybody, if you want to raise your hand and ask a question, once you have raised your hand, Tara will get to unmute you and you can ask your question without typing it. All right, Tara, go ahead.
Hey, Lisa wants to know, are you saying that if they don't ask other candidates to do a physical as part of the hiring process, then if they ask you, it's discrimination?
So if this is job offer, pre-employment, they cannot ask for any kind of physical unless every single job that or employee that is applying for that job is also doing that physical. If you have a disability that is perceivable or, and they think that you may not be qualified to do the job and they ask only you to do that physical exam and not anyone else, that may be considered discrimination. So remember, pre-job offer, pre-job, they cannot ask for a medical examination unless every single employee is doing that examination as well.
Fantastic. Can you stop sharing your screen, Oscar?
Okay, yes, got that.
Just so I've got a better, there we go. All right. When you work with an employer, my experience is that you have a 2-week turnaround time or the process has to start over or reopen.
Are we talking about the reasonable accommodation process or possibly? What kind of process is
Yes.
reasonable? Okay. So a reasonable accommodation process is ongoing. As I mentioned, there is no kind of formal process of what needs to be done. Every single employer will have their own policy in place. Ideally, they should have a policy in place for how reasonable accommodations are asked. But if it is kind of a timely process, and let's say you might have missed a step and they ask you to restart it every 2 weeks, and you keep providing them the same information, that may also be, a little bit of a protected action because employers are not allowed to keep asking you the same questions over and over again and asking proof of your disability if it has not changed too much and you've already provided them with sufficient information. So it really kind of depends on, what are they asking? Are they continually asking for your disability information? Um, those kind of things.
She continues with, I'm asking in regard to their third party, like Sedgwick or Aflac.
I believe there's some limitations on the ADA where insurance the information is not really kind of viewed it if it's not for a reasonable accommodation. Um, if it's kind of to obtain health benefits, they may have their own criteria. I'll have to, if you want to email me, I'll be able to send you that language specifically. If we're looking at possibly FMLA, that's a separate law that requires, periodic check-ins. Sometimes, that may also be something that you may have to provide, especially if you are utilizing leave as a reasonable accommodation. So if, let's say, you exhaust FMLA, and you still need time off because of your disability, you still can't come back, leave can sometimes be utilized as a reasonable accommodation. They may ask for check-ins every once in a while just to make sure that you are um, make sure that the leave is still going to be reasonable.
Can you mention again all the people that can provide a note about your accommodation?
Are we talking about the qualified professionals?
Yes.
Yeah. So qualified professionals, let me pull that one back up just so I can start naming them off. So it's someone that essentially is well aware of your condition, and is qualified to provide those details. So someone that is possibly certified. So here in my slide, I had doctors, which of course include psychiatrists. We also had psychologists. We had nurses, physical therapists, occupational therapist, speech therapist, vocational rehab specialists. So oftentimes, a lot of people working with the vocational rehab department, they're also heavily involved in making sure that their uh, clients are able to kind of go into the workplace, ask for reasonable accommodations, and even utilizing a job coach during the process can be utilized as a reasonable accommodation. So, helping you kind of learn your job, having someone else be there teaching you, that can be a reasonable accommodation. So to continue that list, we also had licensed mental health professionals.
Could staff of a Center for Independent Living that has that consumer on their caseload, could they actually provide anything?
They may be able to provide for the medical documentation part, if they are certified in their field, are qualified professionals in their field, and have knowledge of what their disability is and the functional limitations that the client has. But if you're just helping them ask for a reasonable accommodation or getting that process started, more than certainly you can do that for them.
Okay, does anybody else want to raise their hand and ask a question?
So a therapist would qualify.
Yes. And so, going back to a reasonable accommodation request, it has to be tied back to what is the barrier that your disability is causing at your job. So the accommodation request has to be tied back to your disability and the barrier that you are facing at your job. So, for example, this is off the top of my head, so it's going to take me a quick second. But if you're asking for a reasonable accommodation and you have a disability, but it's not impacting your job at all, then they may not, they may not grant that reasonable accommodation because it does your disability may not have nothing to do with your essential functions.
Okay. Ms. Sanders has a question. You can unmute yourself.
Okay, this is Tiana Sanders, and I was wondering about someone who's been placed in a job, and the job was done a little bit of restructuring for where there were certain job duties that they didn't have to do, and then management changed hands a little bit, not like the whole store, but just like a retail place. And then that person decided that everyone needed to do every job a little bit. So this person wasn't able to do certain jobs like run the cash register and things. So their hours were cut back to where they were only working 1 day a week and are having to search for other employment. I don't know if anything was, really put in writing, but that wasn't what they were, the terms they were hired under. Does that count or is that just tough luck?
That is always on a case by case basis. So we do have sometimes when new management comes in and now they're saying they're trying to apply a blanket policy. And of course, they're saying everyone has, in another example, everyone has to come back to work because now it's a new manager and he wants everyone back in office. If individuals already have reasonable accommodations in place, ideally those should be in writing. Sometimes they may not be, but the job would have to come back and look at what is considered an essential function. So they would have to kind of be able to provide those details. Should a complaint be filed, should a grievance be filed, the burden of proof typically always kind of falls back on the employer to prove that they did not discriminate. And so the more information that individual, if they are going to file a claim, they should provide as much detail as possible as to what's happening, what incidents are occurring, and if they are, if they feel like they ask for reasonable accommodation with new management and that new manager is not hearing them out at all, that can be certain grounds for discrimination if they refuse to hear from the employee about a reasonable accommodation request.
Any other questions? Or comments? Personal experiences you want to share?
It's a running joke with us about it always depends because everything is always so individualized.
Mhm.
But yes, reasonable accommodations, just like reasonable modifications, are always individualized and are on a case by case basis. Um, so that is one
And
of the
and
important
may
things.
change over time,
Mhm.
or may change periodically if if you have a flare
Mhm.
um, of the disability, it may, change a little bit and then go back to uh, the basic where it was. So,
Yeah, sometimes when people have flare-ups that we've gotten calls on, usually their reasonable accommodation request is being able to come in a little bit later from work or being able to stay at home that day and continue their job functions. Of course, this always comes down to what is your job function?
mhm.
For example, if we have an individual with multiple sclerosis who is asking for reasonable accommodation as a standing desk, that is something that they can provide. And let's say that their entire job function is clerical duty, so they're just on their desk or on the computer typing away, and their manager decides to let them know that, hey, we need you to move these boxes of copy paper from one floor to another. That might not be their essential function, and they can possibly offload that function to someone else.
Okay, there's no other questions or comments at this time. Well, once again, Oscar, I want to thank you so much for this presentation. As Tara has said before, we will be sending out the recording and the slides to this presentation. You will get that in the mail. Please remember before you go that we have a short survey. It's only a couple of questions. If you would please answer that survey, it would sure help us out a lot. So thank you for your time today and have a great rest of your afternoon. Bye-bye.